The Costle case raises the issue of how active can a president or other members of the White House staff be in trying to influence what it is that agencies do. You might originally think that, well, it shouldn't be much of a problem. If agencies work for the president and work within the executive branch, presidents should be able to tell agencies to do whatever they want. But remember, the idea behind this is that agencies have special expertise and also a special obligation to listen to what the public has to say, and that they're supposed to arrive at interpretations of statutes and arrive at policy by looking both at their expertise and at what the public wants. And if you believe that, then you might say, well, maybe the president should not be overwhelmingly involved in what it is that agencies eventually conclude. Costle is a case that asks how influential a president can be without saying so in becoming involved in agency decisions. That is, Costle is not a case really about whether or not the president can exercise influence over an agency, or whether a president can inform the agency what it is that he or she would like to see happen. What Costle asks is, how much should the public know about what the president has told the agencies? And so if you look at Sierra Costle in the book on page 154, what we have is a situation in which at the 11th hour of a particular regulation, Jimmy Carter and members of Jimmy Carter's staff spoke in person to members of the EPA staff, giving them information, we assume, about what it is that the president felt was important in interpreting the statute that was at issue. The trouble, according to the plaintiffs in this case, was that the president's words and the words of the White House officials were not contained in the record. And that's important because the APA says that everything that an agency considers must be part of the record. That's important because if a court is going to determine at some point whether or not an agency has reached a decision in a reasonable way, reached a decision that is supported by fact, reached a decision that is not arbitrary and capricious, the only way you can know whether an agency has acted in a proper way is to know what evidence it had before it. Now, if the evidence is written, we've seen that all becomes part of the record. You know, letters that members of the public write and send to the agencies, things that the president writes in reports, or things that his staff members write in reports that end up going before the agency. All of those things. And so you can look at the entire record and say, well, you know, based on all of this information, I think that the agency acted in a reasonable way, or based on all of this information, I don't think there's anything in here to justify the decision that the agency reached. But it's hard to do that if you actually don't know what the agency considered. And so here the question is, if the president or some other member of the executive branch comes in and talks to the administrator of the EPA or to other EPA officials and says such and so, does the public have the right to know what was said? Because that, in a way, is information that could be depended upon in reaching a conclusion. Well, the court in this case finds, and I think reasonably so, that conversations, oral communications from the president and the president's staff need not be put on the docket. That is, they need not be transcribed or described in any way that goes into the official record. The reason that the court says this, there's a practical reason and maybe a philosophical reason. The practical reason is that we all know that presidents and members of the president's staff will talk to agency officials. They'll talk to agency's officials at lunch, during golf games, late at night over pizza, all of these kinds of things. We know these discussions take place, and it would be perhaps naive to think that all of these small discussions would be reduced to writing and put somewhere in the record. And so in one way the court is simply saying, look, the president has a right to have these kinds of discussions, and we're not going to require that every single one of them be written down. The court attempts to justify this in terms of practicality, but also in terms of a philosophical argument, which is an argument against a plural executive. That is, the court seems to be saying, well, the president has the right to have a unified, a unitary executive branch of government, and to make sure that everybody's on the same page. And that's the best way for government to work because it's efficient, and it's also what was intended under the Constitution, because the framers didn't want what was called a plural executive, as the court says. So that's the philosophical idea of a unitary executive, a very strong executive with concentrated powers. Another argument that the court makes is that, well, you don't have to worry about this anyway because the APA says that agency decisions have to be based on evidence in the record. And so no matter what, the evidence on the record has to be enough that would support the conclusion the agency brings. And so if whatever Jimmy Carter said in these meetings isn't on the record, we can't say that it wasn't relied upon or considered, but we can say that it isn't required for the agency to have it's not required in a way that the agency would not be able to support its decision without that information. So let me try to say that in a different way. The agency can only justify its decision on things that are in the record. So if the agency intended to justify its decision on something that Jimmy Carter said, it would have to put it in the record. If it didn't put it in the record, then a court would find that it wasn't justified, and the rule would fail. Now, in real life, what happens is the president probably says, hey, I understand that there's enough evidence to justify answer A, answer B, and answer C. But you know what? I really want you to go for answer C and not answers B and A. And then the agency administrator might say, okay, we'll go ahead and do that. And now that's okay according to this court, because if answers A, B, and C were all justifiable, could all be justified under the evidence in the record, then it makes no difference that a word from the president influenced the ultimate decision, because the APA doesn't guarantee you any particular decision. The APA guarantees you a decision that is based reasonably on the evidence. And we all know that there might be more than one answer that could be reasonably justified by the evidence. And so it's kind of a split, kind of a compromise in this decision. Environmentalists didn't like it at the time because they want lots of transparency. They want to know everything. That is the end of administrative law in terms of this set of YouTube lectures. Thanks very much. I hope I've tried to make it as entertaining and simple and clear as it can possibly be. I'm sure it's also been pretty corny, but it's been a very, very long day for me. So anyway, I wish you well, and we will see you next time in class. I hope. Keep safe and think good thoughts. Farewell. Bye.